Hello, everyone, and welcome to Thursdays Live with Chug. Each week, we cover pressing topics that matter to you and your business. My name is Arianna Gonzalez, and I'm tuning in from our San Diego Chug LLP office. And joining me today is attorney Swapnali Kelkar from our Edison, New Jersey office. Hi there, Swapnali, and welcome.
Hey, hi, Arianna. How are you?
Doing well. Thank you for being here. For today's topic, we're going to be talking all about the August Visa Bulletin updates and covering the most common questions that we've been asked about this since the updates came out. Just a quick disclaimer before we begin, we are live on YouTube, LinkedIn, and Facebook, and this conversation is for informational purposes only. It does not create an attorney-client relationship. So please comment your questions below or email us at info@chug.com and we'll be happy to help you out. So let's get right into it, Swapnali. Can we talk about what's the priority date? We keep seeing this pop up. Can you talk a little bit about what that is?
Yeah, sure. And first, I want to thank you for picking up this topic because of the retrogression which everyone is going to see in the August Visa Bulletin. Everyone, I'm pretty sure that the people out there must be waiting to hear about this topic. So really thanking you for picking up on this topic. Now let's dive into your first question, what's the priority date? And I would say, for anyone to understand the visa bulletin, it's first necessary to understand the key concepts used in this visa bulletin. And one of the key concepts used is the priority date, right? Now, a priority date is the date when the immigrant petition is properly filed with USCIS. Now, in some instances, the priority date is the date when the labor certification application was accepted for processing by the Department of Labor. Now, we all know that we have, we can seek green cards either through family based preferences or through employment based preferences. Now, if you are trying to file an immigrant petition from family based immigration point of view, then in that case, you can see that the I-130 petition or petition I-360, that you can go ahead with. Or if it is employment-based preference, then in that case, the filing of I-140 petition or maybe I-526 can establish your priority date.
That's really helpful to know regarding the priority date. So let's get into a little bit about the Visa Bulletin. What is the Visa Bulletin and who publishes this? Why is it relevant? Can you talk about that a little bit?
So Visa Bulletin is published by the Department of State every month, and it lists the cutoff dates that actually governs the visa availability. Now, in order to adjust the status to that of a legal permanent resident status, an immigrant visa must be available to the applicant both at the time of filing the adjustment of status application and at the time of its entire adjudication process. So when the retrogression happens, it indirectly impacts the adjudication process of that adjustment of status application. So it is necessary for an applicant to understand whether his priority date is earlier than the cutoff date which is published by the visa bulletin. Now, we have to keep an eye on every month's visa bulletin. It's possible that your priority date might be current as per this month's bulletin, but there is a chance that it might not be current for the next visa bulletin, right? So visa bulletin cutoff dates matters a lot for every applicant who has a dream of becoming permanent legal resident or who has a dream of obtaining an immigrant visa. And it's the Department of State who publishes it every month.
Thank you for that overall overview of what the Visa Bulletin is. That's really helpful. So everyone's talking about this visa retrogression that happened. Can you talk about why visa retrogression happens and what do we know about this?
Most of the time clients do ask us why the dates are retrogressing when you are seeing the progression and suddenly you see that now the visa dates are going back or push back, and why it is happening. I think the reason for this is when the demand for visa numbers is more than its supply, when the ratio is inverse in between the demand and supply of the visa numbers, the retrogression is tend to happen. In other words, when more people apply for a visa in a particular category or maybe from particular country, then there are visa available for that particular month, right? Then the visa dates do retrogress. Now, typically, we have seen retrogression happening towards the end of the fiscal year, and I would say, we are moving towards the end of the fiscal year 2023, right? And we hope that this retrogression will be restored, this visa bulletin will be restored by the beginning of the fiscal year, as the new supply of visas will be made available by the beginning of the fiscal year. So everyone is hoping on the October visa bulletin, and we hope that at least we like the visa bulletin will get restored to where we are, and people will get some kind of a relief seeing the October visa bulletin. So let's hope for the best.
Fingers crossed that there's no more retrogression and people can get the information that they need and get their visas and everything stays on track. So I was looking over the visa bulletin and it describes a lot of charts. There's a lot of information on there. Could you talk a little bit about which chart I should look for if I want to, for example, apply for an immigrant visa or my green card?
Sure. And I think that's a great question, because most of the time people get confused seeing these multiple charts, right? Now, the first thing what we have to understand is, what is my preference category? Am I trying to apply through a family based, or am I trying to apply through an employment based? The second thing any applicant needs to understand is, what's my priority date, right? Then the third thing the person needs to understand is, which is my country of origin, what is my country of birth? Because the visa bulletin is framed based on, and all these cutoff dates have been based on the country of your origin or country of your birth. So I have seen sometimes people say okay, I'm born in India, but I'm an UK national. So can I look for my visa bulletin dates under all chargeability? And the answer to that question is no, because the visa bulletin is framed based on the country of your origin and not country of your nationality. So that's one of the important thing every applicant who wants to check his priority date needs to keep it in mind. Now, as I said, the visa bulletin gives you the cutoff date charts for family-based and employment-based visa applications. You will see that visa bulletin gives, right, the final action date chart, which usually we refer as a table A, for each of the visa categories. Either it is under a family-based or either it is under the employment-based, okay? And you will also see another chart which says dates for filing chart, which we usually call as table B. Now, why there are two charts and what exactly these two charts are trying to tell us, right? Now, we are aware that visa bulletin gives us cutoff dates, and for me to be become eligible to apply for, it's necessary that my priority date has to be earlier than whatever cutoff date is published in the visa bulletin for that particular month and for that particular visa category. Now, if I'm looking at the final action date, right, what that final action date chart is actually telling me. So final action chart is telling me that whatever cutoff date is mentioned in that particular chart, right, if my priority date is earlier than that cutoff date, that means I'm entitled for a grant of permanent resident status. Or maybe I'm entitled for granting an immigrant visa. So I'm eligible for it. I can get the green card, okay? At the same time, I can say that means I'm even eligible to apply for it, right? Now, if that's the case, then what the table B, which is the dates for filing chart, is actually explaining us. Now, let us take an example through which, I will try to explain more about how this dates for filing chart actually works. Now, we can seek green cards by two ways, right? Either we can get it when we are in the US by filing adjustment of status application, or if you are outside US, you can even get the green card through consular processing. Now, this dates for filing chart actually tells you when you can file an application for your immigrant visa or for adjustment of status, right? So if there is someone who is outside United States with an approved immigrant petition with an established priority date, he can refer to dates for filing chart. And if he sees that his priority date is earlier than the cutoff date mentioned on the chart, then certainly he has to wait for an email notification from the National Visa Center where a case will be generated for that particular person. And after that, he can start submitting his application, he can prepare the documentation, he can submit all the documentations, and then he can proceed through the first step towards applying for the immigrant visa application or petition. Now, the only hiccup here is if his priority date is not current as per the final action date chart, right? That means as per the dates for filing chart, he can only apply, but he is still not entitled to get his immigrant visa, or he is still not eligible to get his permanent resident status, right? Now take up another situation when you are actually in the United States and you have an approved immigrant petition, your priority date is established. And now you are going to check whether you can submit the adjustment of status application while being in the United States. Now you can refer to both these charts, but if you want to file for an adjustment of status application, it's necessary for you to refer to USCIS Visa Bulletin information page, which actually further goes ahead and tells you to which chart USCIS is referring to, right? Because the Visa Bulletin is published by the Department of State and the adjustment applications are adjudicated by USCIS. So it's imperative for you to go and check on the USCIS website, the Visa Bulletin page, and you have to check whether USCIS is referring to the final action date chart or whether USCIS is referring to dates for filing chart. If USCIS is referring to final action date chart and if your priority date is current as per that chart, you can go ahead, you can submit the application, and at the same time, it means you're eligible to grant permanent resident status. But if USCIS is again referring to only dates for filing chart, then in that case, you are just entitled to file the application, but you will still have to wait till your final action date chart, your priority date becomes current as per your final action date chart. So a little bit complicated, but you have to understand the difference between these two tables to determine when actually you are eligible to get your permanent resident status.
That's really helpful and quite a bit of information. So if you are going through this process, make sure you're checking with your immigration attorneys that you are doing the process correctly and everything looks good, because it's better to get it right the first time. So let's talk a little bit about the impact of the retrogression on pending visa cases. What does that look like for cases that are pending right now with this retrogression happening?
Right. So most often, clients ask us, when we submitted our adjustment of status application, the dates were current, now dates are retrogress. So what's its impact? What does it mean for us? What is going to happen with our pending, adjustment of status applications? The simple answer to this question is when the visa number is not available as per the final action date, right? Then all these adjustment of status applications or all these immigrant visa applications will be held in abeyance until that visa once again becomes available. So USS is not going to adjudicate any of such applications, or USS is not going to take any action on any of such applications. Now, when I'm saying any of such applications means the 485 applications, right? The actual application applying for a green card. So in that case, I would say the wait period for such applicants is more. They still have to wait till their priority date becomes current as per the final action date chart. And once it becomes current, the USS will resume adjudication of all these applications, and then only such applicants will be entitled to get their green cards.
That's good to know. So the people that are experiencing this, these applicants, are they able to work and travel during this time? What does that look like for them?
Yeah. So as I said, suppose the final action date was current, somebody filed his 485 application along with the EAD application and travel permit, which is an advance parole application. Now the dates retrogress. So as I said, USS is going to hold on adjudication of the 485 application, but USS will not hold the adjudication of the EAD or the advance parole application, because these applications are basically offering the benefits to the applicant of pending adjustment of status application, and USS is not going to hold the adjudication of either the employment authorization applications or the travel permits. So such applicants are still entitled to receive their employment authorizations. They are still entitled to receive their advance parole. Not only that, but the applicants are even entitled to get their work authorizations and travel permits extended, right, till the time the visa number becomes available to them again. So throughout this process, if there is a retrogression and because of which your adjustment of application is put on hold, still you can continue with your employment authorization application, you can continue with your travel permit application, and you are entitled to get this EAD and travel permits. You can work during that time, you can even travel during that time. Even if you are going to lose your non-immigrant status, that's fine. You can still, with the help of these EADs and travel permits, you can work, or maybe you can travel outside. So I think that's a great relief which all these applicants can have while the retrogression is in place and while they're waiting for their visa numbers to be active.
That's great to know that these applicants still have the ability to work and travel during this time. So just for everyone who's barely joining us and just tuning in, just a quick disclaimer for everyone who's watching. We are live on YouTube, LinkedIn, and Facebook, and this conversation is for informational purposes only. It does not create an attorney-client relationship. So please comment your questions below in our comment section or email us anytime at info@chug.com so we can help you out. So let's get into the next question, Swapnali. Is it mandatory for the applicant of the adjustment of status to maintain their non-immigrant status while the adjudication of his application is on hold due to the retrogression?
Yeah, another great question, I would say, because most of the time people do ask us, hey, I'm on H1B, my adjustment of status application is pending. Is it necessary for me to continue with my non-immigrant status? Or maybe I'm on L1, and is it necessary for me to continue with maintaining my non-immigrant status? I would say there is no statutory requirement as such where such non-immigrants need to continue with their non-immigrant status. Just if they are just an applicant of pending adjustment of status application, they are authorized to stay. At the same time, if they already have their EADs in their hand, their work authorizations are already approved, they can even go ahead and work. So I would not say that it's absolutely necessary to maintain your non-immigrant status while you are an applicant of a pending adjustment of status application. But I do recommend maintaining your non-immigrant status, because unfortunately, suppose if your green card application is denied, right? And if you are not maintaining your non-immigrant status, then in that case, once the denial is going to happen, you will not be in any kind of a status, and you will start accruing your unlawful presence, and probably you will have to leave the country. So I would say maintaining a non-immigrant status may act as a backup, so that in case if your green card application is denied, you can still be in the country and try to explore some other options of being in the country. But otherwise, if you're not maintaining your non-immigrant status, and unfortunately if the green card application is denied, the only option what I can see is they might have to leave the country immediately.
Thank you for that insight, Swapnali. So we do have a live question from our audience. Is it okay if I bring that up right now?
Okay, go ahead.
So they're saying that they filed an I-140 and an I-45 concurrently in December of 2022, when the dates for India were current. Their I-140 got approved. Will their EAD/AP application be processed?
Yes, so I think we just now covered this, right? When you asked me about what happens, whether these people are entitled for any type of work authorization or travel permits. So my answer is yes, because these are the benefits awarded to an applicant of an adjustment of status application. Even though the dates are retrogressed, still USS is not going to hold on adjudicating your EAD applications or travel permit applications. USS will proceed with adjudicating these applications, and I hope that soon you will see an approved EAD card in your mailbox. Yeah.
Thank you for answering that question to our viewers. I hope that was helpful. If you need more insight, please email us anytime. So we do have another question. What is happening with children on their parents' application? Do you have some insight on that?
I think we are about to cover about the aging out kids and all that. So probably I will answer to that question when we will reach to that question.
Yeah, we'll cover that soon.
Yeah.
So let's get into our next question. We're close on time, so let's continue. What are the options available to the AOS applicant if they lose their job during the visa retrogression? I'm also asking because we have seen the massive layoff happening in the tech industry. I'm sure everyone who's watching has seen that. So do you have some insight on the options available to these applicants?
Yeah, absolutely. Like layoff is such an unfortunate event in anybody's life, and most of the people nowadays in the tech industry are facing this. So another great question, I would say, if it's not the loss of a hope, but if you face any layoffs while your adjustment of status application is pending, make sure that your application is, and if your application is pending for more than 180 days, then you have another option of porting your employment to some new employer. You just have to make sure that the new job offer is offered to you in the same or similar occupation of your original job offer. And how that can be determined, you have to just check whether the new job is resembling with the original job offer in respect to its job duties or the job title or maybe required skills, education, experience, etc. But yes, you can port your employment to the new employer, and there is a separate process for it. So I'm not going to discuss the process right now over here.
That's really helpful insight. Is it possible to change the employment-based preference category if the PD of the applicant is current as per the other preference category?
Yes. So, and I think most of us must have witnessed this when the EB3 dates were progressed by almost 2 or 3 years in October 2020. So just giving an example, for example, if you have an approved I-140 under EB2 preference category, and if you see that the priority date for whatever is your priority date that is current under the EB3 preference category, right? You can certainly file another I-140 immigrant petition under EB3 category, okay? And then you can just downgrade and you can change your visa preference. Make sure whether you are to whatever visa preference you are switching to, make sure that you have to still fit within the regulatory requirements of that particular visa preference category. And if you can fit yourself within that, go ahead and do change your visa preference categories if you see that the priority dates are current for that particular visa category. That is doable. Yeah.
That's great to know that sometimes applicants can choose to change their preference category. So let's get into that pressing question. How does retrogression affect the kids aging out of AOS applicants? Does it affect them? Let's cover that.
Yeah, absolutely. So the delays in visa availability always adversely affect the aging out kids. However, aging out kids can benefit if they qualify for SUSPA, so SUSPA is Child Status Protection Act. Now, the SUSPA age is locked when the visa becomes first available to the applicant. The applicant sought to acquire the visa within a period of 1 year once visa becomes available for the first time. Now, if the visa becomes unavailable due to retrogression and does not remain continuously available for a period of year, then the applicant gets another new year to apply when the visa becomes available again. However, USCIS will check the SUSPA age of that particular applicant at that point of time. So what is a SUSPA age? Basically, SUSPA age is the requirement for the kids to apply for a green card is the child has to be unmarried, the child has to be the child should not be older than 21 years old, okay? And then to calculate the SUSPA age, we have to see how long the immigrant petition was pending for that particular applicant, and whatever period whatever period the immigrant petition is pending, you can deduct that particular duration from the kid's age when the visa first becomes available, and then you can see whether the SUSPA age of the kid is falling below 21 years. If that's the case, then the child can take the advantage of SUSPA and may apply for the adjustment of status application. But if the retrogression is going to happen and stays there for more than 3-4 months, then definitely it's going to adversely affect the kids adjustment of status application.
I appreciate you covering that question. Thank you so much. We do have 2 more live questions if we have time for them. One of our questions is there any consideration to give applicants with approved I-140 EAD and AP, similar to the new parole program for some applicants when approved I-130 from the 4 selected countries?
I'm not sure what exactly this person is trying to ask. Maybe can we switch to other question?
Yeah, so when will it resume from current status to active status? Is there any prediction in terms of month? This is for people whose I-485 is still pending and it moved from current status to pending.
As we said, right, we expect that the October Visa Bulletin might bring some good news, okay, and we might see that the dates are getting restored to where they are right now. So probably I would say we will have to wait and see whether we can see any progression with the beginning of the new fiscal year. So we will have to wait to see where, and then we will get to know where these 485 applications really stand, whether they have their final action dates become current or not. We will have to wait for that.
Sounds great. Thank you, Swapnali. For those who questions didn't get answered, thank you for asking your question. And if it didn't get answered, please send us an email with more details and information so that we can properly help you out. We do have time for one more question. If you can offer some insight on this, Swapnali. We just keep getting a lot of questions right now. So any prediction on how much the dates may move in October for EBGC? Do we have an answer for that? I don't know that we can predict that.
Again, I would say it's very hard to predict anything at this point of time. Let's wait. As I said, with the new fiscal year, probably there will be a lot of visas available. So I'm hoping that we will see some progression. But what will be that progression? Whether the EB1 dates will become current? What will be the priority date? What will be the cutoff date for India? I'm pretty sure that most of the people who are India-born nationals definitely they are trying to check on this, but it's very difficult for me to predict on this where we will be.
Of course, definitely. So we'll keep our eyes peeled and stay tuned on our website for updates. We always post updates regarding this, so make sure you're tuned into our updates on that. So last question before we end this, I know we're out of time. So does the AC21 apply for EB1A?
AC21 in what sense? The job portability?
The question just says, does AC20?
I would say ask the person to send us an email so that I can
please
understand the
email us at
question.
info@trug.com and then we'll help you out with that because we might need a little bit more information from you. So we are out of time, so this does bring us to the end of our conversation. Thank you so much everyone for joining us today. To stay up to date, please subscribe and follow us on Facebook, LinkedIn, and YouTube. If this video was helpful, please make sure to give it a like and turn on our notification bell so you can be notified of our next video. If you have any questions or suggestions, please email us anytime at info@trug.com and make sure to join us back here next week for more pressing topics that truly matter to you and your business. Until next time, stay safe and take care. Thank you so much, Swapnali, for your time. I really appreciate you.